You filed your workers' comp claim 3 weeks ago. The injury is real. The paperwork is in. You think the hard part is over. What you don't know is that on the other side of that claim, the insurance company has already started working. The insurance company workers' compensation tactics being used on your case right now follow a script you've never seen. I have. I've been spending years on the plaintiff side watching this uniform playbook run from start to finish. And I want to tell you exactly what's in it. Here's the part that catches workers off guard. The insurance company is not waiting to see how your recovery goes. They started their process the day your claim hit their desk. There's an adjuster assigned to your file. There may already be an investigator. And the moves they're making in the first 30 days are the ones that tend to determine how much this case is ultimately worth. This video covers each stage of the standard insurance playbook, what they do, why they do it, and what it costs you if you don't know it's happening. By the end, you'll understand that what felt like a routine claim process has actually been an active effort to minimize what they owe you. The recorded statement request. Within days of a claim being filed, many injured workers receive a phone call from the insurance adjuster. The tone is usually friendly. They say they just want to understand what happened. They ask if you'd be willing to give a recorded statement. Most workers say yes, because why wouldn't you? You're telling the truth. You have nothing to hide. Here's what you need to understand. That statement is not for documentation purposes. It's a tool for creating inconsistencies. The adjuster has been trained to ask questions in a sequence that surfaces gaps, contradictions, or admissions that can be used to minimize the claim or dispute the injury entirely. They'll ask you about your medical history, about prior injuries, about activities outside of work. They'll ask about the accident in multiple different ways at multiple different points in the conversation. If any answer you give today can be made to look inconsistent with your treatment records later, that inconsistency will be used. Under the Illinois Workers' Compensation Act, you are generally not required to give a recorded statement to the insurance company. You have the right to consult with an attorney first. If you've already given one, that's not the end of the claim. But if you haven't yet, stop before you do. The early settlement offer. Some workers receive a settlement offer within the first 30 to 60 days of filing. The offer comes before treatment is complete, before you know the full extent of your injury, before maximum medical improvement has been reached. The adjuster will frame it as doing you a favor, getting you money quickly so you can move on. The offer is designed to close out your case at its lowest possible value. The insurance company knows your injury is worth more than what they're offering. They're offering early because they know that workers who don't have legal representation tend to not know what the actual case is worth. They're betting that a check today looks better than a number you can't see yet. Accepting a commission approved settlement means signing away future cash and medical rights related to that injury, unless the settlement contract expressly keeps a specific benefit open. Medical costs that appear later, wage loss, permanent disability. A settlement is not legally binding unless the Illinois Workers' Compensation Commission approves it. But once approved, it generally closes the file. That's what they need from you. I've reviewed enough early settlement offers in Illinois cases to tell you that they're almost never in the injured worker's interest. The IME, their doctor, their rules. Around weeks 4 to 8, many injured workers receive a letter scheduling them for what the insurance company calls an independent medical examination. The doctor's name's unfamiliar. The appointment is at an office across town. The letter implies this is a standard part of the process. The IME is not independent. The doctor performing your examination was selected by the insurance company and is paid by the insurance company. In many cases I've handled, IME reports are used to challenge the treating physician's findings, to argue that your injury is less severe than documented, or to claim that you've reached maximum medical improvement before your own physician believes you have. I've deposed IME doctors in arbitration proceedings. I've read hundreds of the reports. The pattern I see in insurance selected IME exams is consistent. The injured worker and injury is characterized as less serious than their reported recovery. Recovery is categorized as further along than the treating physician believes, and return to work is recommended soon. You are required to attend the IME under Illinois workers' compensation law. Refusing to attend can get your benefits suspended, but you have rights around that process that protect you. And the IME doctor's report is not the final word on your medical condition. We go deep on the IME in a separate video on this channel. The link is in the description, and it's important enough that I'd recommend watching it before your appointment, not after. Surveillance. What they're looking for at some point during your claim, in many cases within the first few weeks of filing, the insurance company may hire a private investigator to follow you. They watch your home, they follow your car, they film you doing yard work, carrying groceries, walking the dog. They'll be there on a day when you feel better than usual and you push yourself to do something you've been putting off for weeks. That's what they're waiting for. Surveillance footage is used in two ways. First, as direct evidence to challenge your injury at an IWCC arbitration hearing if it shows you performing physical activities inconsistent with your stated limitations. Second, and this is the more common use, as leverage. They don't always have to file it. They just have to let you know they have it. Workers who don't know how to respond to that pressure often accept worse outcomes than they would have expected if they'd been advised correctly. The rules on what surveillance is legal and what crosses a line matter here. A private investigator can film you in a public place or from a public street. They cannot film you inside your home. They cannot harass or intimidate you. If the behavior moves past filming into something that feels like following or contact, document it and tell your attorney. What you do during a workers' comp claim, especially in places where you could be observed, should be consistent with what your injury allows. If you have a good day, you're allowed to have it. Just understand that someone may be watching. The return to work pressure play. One of the most effective tools in the insurance company's playbook doesn't happen at the insurance company's office. It happens at yours. After a claim is filed, many employers begin a quiet process of adjusting the worker's job description. Suddenly, there's a light-duty position available that didn't exist last week. The employer submits paperwork to the insurance company, documenting that modified duty is available, and the insurance company uses that paperwork to reduce or eliminate temporary total disability benefits. TTD, which is the income replacement benefit you receive while you're unable to work, is only available when you're actually unable to perform your regular job or a suitable modified duty role. The pressure often comes from HR, not the claims adjuster. You're told that modified duty is available, that it falls within your restrictions, and that if you don't report to perform it, your benefits may be affected. In some cases, the modified duty being described genuinely is within your restrictions and is legitimate. In others, the restrictions have been taken from the IME report rather than your treating physician's orders, or the description of the modified duty doesn't match what you'd actually be doing on the floor. Both of these scenarios deserve scrutiny. If the restrictions being used to assess your modified duty assignment came from the insurance company's doctor rather than your own, that's a problem worth raising with an attorney before you comply. How to counter the playbook. Everything I've described follows a pattern because it works on workers who don't know what's happening. The counter to each move is the same. Document everything in writing. Do not give a recorded statement without consulting an attorney. Do not accept an early settlement offer before your treatment is complete. And you understand the full value of your claim. Understand that the IME doctor is not your doctor, and their report is not the last word. Keep your activity during the claim consistent with your physical restrictions, and treat any pressure around return to work or modified duty as something worth verifying independently before you act on it. The playbook I've described is standard. Insurance companies run it because it's effective and because most injured workers have never heard of it. Now you have. The workers who fare best in Illinois workers' comp cases are the ones who understand what's being done to them early enough to respond to it rather than after the damage is done. If you're in a claim right now and anything I've described matches what you're experiencing, a recorded statement request, an early offer, an IME notice, a new modified duty assignment, reach out before the next step happens. The contact information is in the description. If you want the deep dive on the IME specifically, what the exam is, who the doctor actually works for, and what you should and should not say before you walk into that room, I have a full video on this channel dedicated to that. It's one of the most important pieces of information any injured worker in Illinois can have before that appointment. Link is in the description. And if you want to talk through that specific situation, contact information is there as well. The consultation is free.